Once an individual has been convicted of a crime, the court must impose a sentence. It's probably the hardest thing the court does. The limits of the sentence are are set forth in the law that prohibits the conduct that brought the person to court in the first place. It is important for the judge to focus on the judicially determined objectives of imposing a sentence. The law requires the judge to impose a sentence that is designed to accomplish the following four objectives. First of all, to protect society. Secondly, to discipline or punish the wrongdoer. Thirdly, to deter the offender or other people from committing offenses in the future. And finally, for any rehabilitation, if it's possible, of the offender. Note that the three last objectives that I just mentioned are in one way or another a form of deterrence. Since the purpose of deterrence is to protect the public from future criminal exploitation, all of the objectives have the same purpose, and that is to protect the public. Requiring retribution and providing for rehabilitation are specifically aimed at deterring the offender from future criminal conduct. The court's duty is to individualize the sentence to this defendant and the offense committed. I am quoting from the case of People v. Chapa, 407 Michigan 309, the 1979 case, where it says, "It is incumbent upon the sentencing judge to exercise his discretion so as to individualize the sentence to the particular circumstance of the case and the offender. The sentencing judge is not permitted to abdicate his discretion to individualize the sentence to either the local policy or his own preconceived notions." And the case that states that in our law is People v. Mooson, 109 Michigan Appeals 39, a 1981 case. Our law requires the judge to individualize the sentence to the particular circumstances of the case and the background of the offender. A judge who allows local policies or the judge's own or anyone else's preconceived notions to influence the sentence imposed is not fulfilling the duty of fairness required of all judicial actions. The law requires the judge to impose a sentence that is fair in relation to other sentences imposed on persons of like and similar backgrounds who committed like and similar offenses. By background of the offender, we mean the criminal history and not the multitude of factors that make us all different from one another. It is easy to see that it is unfair for persons of like and similar backgrounds who have committed like and similar offenses to receive vastly different sentences. We have been striving to eliminate race, ethnic background, religion, gender, and all other considerations, such considerations in the evaluation of people. The same applies to a person's position as a celebrity. In this case, the defendant is convicted of carrying a concealed weapon in an automobile. All offenses involving weapons are serious because of the dire consequences to human life that could result. In this case, the weapon was not loaded and there was no direct threat to human life. The defendant in this case is 28 years old. He is married, the father of one child, and has no prior convictions. The court is aware that there was a prior altercation in 1994 that was 7 years ago in St. Clair Shores, and in that matter, the defendant's plea was taken under advisement and the charges dismissed after 1 year. The court therefore feels that justice will be satisfied in this case and the objectives of the court of the law be satisfied by following the probation recommendation. I am going to sentence the defendant to 2 years probation with the following special conditions. First of all, that the defendant shall refrain from all excessive use of alcohol and any controlled substance unless specifically prescribed for the defendant by a physician. The defendant shall comply with the requirement of alcohol and drug testing ordered by the probation officer or law enforcement at the request of the probation officer, with the minimum frequency determined by supervision standards. The defendant shall not make any attempt to submit fraudulent or adulterated samples for testing. The defendant shall not hinder, obstruct, tamper, or otherwise interfere with the testing procedure. The defendant shall have no contact with John Guerra during the probation period. The defendant shall not engage in assaultive behavior. The defendant shall participate in counseling as directed by the supervising probation officer. And the court is specifically requesting that Carla Molly be assigned to this case as the supervising probation officer. She has done the pre-sentence report and is familiar with the background of this defendant and what is necessary in this case. The defendant shall not own or possess firearms during the term of probation. Firearms or other weapons. The defendant shall pay $5,000 in court costs within the next 30 days. The defendant shall pay $30 per month state supervision fee, and the defendant shall pay $2,500 of fine to the Macomb County clerk in the next 30 days. The defendant shall pay $60 to the Crime Victim Rights Fund in this particular matter. With that sentence, the court feels that in this particular matter, this offense is at an end. I would tell Mr. Mathers, in this particular court, is not, I put probation terms. I consider probation to be a punishment for an offense. I don't think it's a lark, and I don't think it's a slap on the wrist. I consider it a very serious matter. In the next 2 years, I would advise you to pay very close attention to what is your responsibilities under these probation terms and carry them out. If you come back before the court, you are subject to a sentence of up to 5 years in the state prison. The court considers any violation of probation extremely serious. With that, I want to hand to you your advice of a rights form in this particular matter that does specifically state in detail your rights to appeal this conviction in this particular matter and the sentence. I'm going to ask you. All right, thank you, counsel. Oh, yes, I will. This court feels that based on his specific circumstance, and as I said, our duty is to individualize the sentence, that I am going to permit travel for work purposes within the continental United States. Of course, I will require that he submit a retinue, or whatever you want to call it, the itinerary of his travel to the probation officer so she knows where he's at. But I am permitting him to travel within the continental United States. If his work calls for him to travel outside of the United States, he is required to get the permission of the probation department, or the court, I should say. The court.